So, this is about Hiibel. I am fully aware, I have read, unlike most people, I have read the U.S. Supreme Court Hiibel decision. Unlike 99.9% of you, I have also read the Nevada Supreme Court Hiibel decision. I also know the underlying facts of the Hiibel stop. One weird thing about cases, about trials, about opinions, is that they can only really address the facts that are before the court. Generally speaking, if they go beyond the facts that are in front of them, it's dicta. It's meaningless, generally speaking. Obviously, there are exceptions, especially where other courts like the dicta. But in Hiibel, when they stopped, or when they started asking Hiibel for identification, they were asking him for his name. He wasn't driving his vehicle at the time. They couldn't demand his driver's license. They were asking for his name. They asked 11 times for his name. And what the Nevada court was addressing, they were doing a Fourth Amendment reasonableness analysis. And they said, well, in this case, he was asked for his name. His name is, everybody gives out their name. It's, you meet someone, you give your name, you put your name on your business card, you have your name on your credit cards. Your name is everywhere. Your name's on everything. You don't have a Fourth Amendment right to privacy on your name. So they were addressing the facts that were in front of them. Now, the question becomes whether the police officers can demand more. And I don't believe that's settled. I don't have access to a law library. I don't have access to LexisNexis. I don't know if it's been addressed. It probably has, because police are going to run into that person out there whose name is John Smith or some very common name, and they're not going to be able to identify the person based solely on the name. And so the question that will be before the court, again, in Nevada, is whether or not, as a reasonableness test, they can demand more than just the name. Whether the statute authorizes it, and whether they can demand it. And to the best of my knowledge, that hasn't been addressed. So thank you to all the people who are posting it ad infinitum. I am aware of it. I know what I'm talking about. I know you all don't want to believe me, but I don't believe that in Hiibel, either in the Nevada Supreme Court case or in the U.S. Supreme Court case, they limited it expressly to just the name. They said just the name was what was asked for in Hiibel, but I don't believe it's limited to just the name. We'll have to wait and see on that one. Either if someone gets to a law library and shows me where I'm wrong, or I get a chance to go to a law library and figure out whether I'm right or wrong. And I could be wrong, but I have a feeling, I have a sneaking suspicion that just a name isn't going to cut it. Do with that as you will. I haven't had a chance to read Kelo, K-E-L-O. Thank you for everybody who keeps sending it to me. That was after I graduated from law school. I have a feeling it's, from what I've been seeing in the comments, I haven't had a whole hell of a lot of time, you may imagine. From what I've been seeing in the comments, it was a taking to give to a private company. Yeah, I can imagine that. A lot of times they are. I mean, even like an arena is oftentimes a private company, but they do an analysis whether it's for the good of the city, where it's for the public good. You know, it's gonna bring in X number of jobs. It's gonna produce X amount of revenue. It's going to revitalize the downtown sector, et cetera, et cetera, et cetera. And I understand that everybody wants to be all pissy about it, and I get it. I'm not the hugest fan of eminent domain myself, but again, the thrust of what I was saying, I believe, is going to hold. Once I get a chance to read Kell, I'll go over it. But at this point, generally speaking, you don't really get to challenge it unless it's something blatantly that's blatantly not in the best interest of the public, or that they can't make a good argument that it's in the best interest of the public. And then all you could really do is quibble about the value, the fair market value. One other thing I do want to remind everybody of is that there will also be state statutes and state constitutions that you have to deal with when you're dealing with eminent domain. Because oftentimes, more often than not, it's the state that's doing the taking, or a municipality or something like that. It's not as common for the U.S. federal government to do the taking. So bear that in mind, that they'll have to comply with the state constitutions, and those may remember that the U.S. Constitution sets the floor, and the state constitutions and state statutes will set the ceiling. It's always more complicated than we want to believe. I know everybody out there is looking for bright line rules, and the more I'm into this, the more I realize that the bright line rules really aren't bright line rules, and they're more meant to be broken. Thanks for watching. Have a great day.